Welcome, everybody. We are going to help you navigate the minefield of special assessments. Now, there's an old saying in the community association industry that the two dirtiest words you can utter are special assessment. And when you say those words, that is when you typically get the most attendance at one of your board meetings. In today's webinar, my partners Joy Mattingly and Jane Cornett we're going to be discussing the mechanics. How do you pass a special assessment? How do you collect a special assessment? And how do you utilize a special assessment? Joy heads up our firm's statewide collection practice, and my partner Jane Cornett heads up our community association practice group in the Treasure Coast. So we're delighted to have you all here, and let's get started. So Jane, let's start with the substantive and procedural aspects of special assessments. Where is the authority to levy a special assessment? Is it in the documents or is it in the statutes?
Well, let's just take one second and say, what is a special assessment? And a special assessment is just what its name implies, something extra, something beyond your annual or quarterly or monthly maintenance that you pay. Some folks call those dues. I've heard it called all kinds of things. But a special assessment is when you have some special need for funding. Now, in the condo and the co-op arena, there is some reference in Florida statutes to a special assessment. And in homeowner and property owner communities, the statute doesn't really address it, but it kind of implies that special assessments can exist because it regulates them about notice for meetings on them. But the statutes don't really give us any guidance about what they are, how they can be used. And that's all found in your governing documents. So you're going to have to look at your declaration, your articles of incorporation, your bylaws. In a co-op, you might have something called a master form deed. But there's going to be some governing documents for your community that are going to say when you need a vote of the board, when you don't need a vote of the membership, when do you need a vote of the membership. There could be all kinds of different requirements, and every community is different. We can't tell you today what's necessary in your community. And we're even going to have to talk a little later about why the special assessment is needed, because that's going to dictate the voting requirements too.
And sometimes the requirement for membership approval is tied, Jane, is it not, to how much the special assessment is going to be, to the amount of the assessment?
Yeah. When clients ask me to help them rewrite their documents, what I typically do is I recommend that the board be specifically given a certain level of authority, but that the big stuff, I usually tie it to the budget, must go to a membership vote. But what's in your documents, unless you have updated, is going to depend upon what your developer just kind of stuck you with.
And it's I imagine it's the same for you, Jane. It's a big difference when we're doing amendment projects and we're looking at specifically at the authority to pass special assessments. There's a greater need for board flexibility when we're talking about a special assessment connected to a repair project, as opposed to a discretionary improvement project.
Absolutely. Adding the new bocce court, which a lot of my clients have been talking about, is totally different than having to fix the seawall so the building doesn't fall into the river. There's a major distinction between the reasons that you're doing your special assessment.
I agree. So Joy, what are the procedural requirements? James just talked about looking at the documents, looking to the statute to see if the board has the authority to pass the special assessment. Assuming we get past that hurdle and Jane has given the legal opinion that yes, the board can pass this, what's the procedural requirements to actually pass it?
Sure. So assuming that the board can pass it, but even assuming it's a membership meeting, the association pursuant to statute, and this covers whether you're homeowners, a co-op, or a condominium association, you're required to give a 14-day notice of that board meeting. You also do want to look at your governing documents, because sometimes your governing documents actually require you to give more notice. But the statute, which is, what I was referring to, requires a 14-day notice, and that's pretty standard in terms of the associations that I've dealt with. The notice has to specifically state that assessments will be considered, and it has to provide the estimated cost and description of the purpose for the assessment. So the estimated cost, again, it's an estimate. So you can always wind up having a different, amount than what that notice says. But you also have to have the description of the purpose for the assessment. That's important, because I've seen people challenge that and say there wasn't enough information contained in the notice as to what the special assessment was for. So those are things that you need to pay attention to. Now, that notice has to be posted on the property, whether, in the homeowners, the condo, or the co-op property. And it also has to be mailed to the owners. Okay, so that has to be done 14 days in advance. And then the association really needs to make a practice of providing or keeping an affidavit that notice was actually posted and mailed. The statute says that the affidavit needs to be executed by the person who actually posted or provided the notice. So most of the time that's going to be an administrative person in your office, in your front office, or your management company. So it's a good idea to do that at the same time as you're providing the notice. It is something we can provide after the fact, but it's better to have it at the same time. So that's the key that you need in order to have the board meeting. And then the other things that we look for are the board meeting minutes at which the board approved the actual special assessment. That's actually can be a very contentious issue later on if owner wants to claim that the board didn't actually approve the special assessment or vote on it at the meeting. I've had that be a big issue before in cases. And then you also want to, after the board meeting takes place, you want to send the owners, you have to send the owners a notice that the special assessment was adopted. And again, you have to include the specific purpose for the special assessment. So I have some clients that say, well, we have the minutes, or, oh, we just sent them a coupon. Well, you really need to notify the owner that the special assessment was passed for a couple of reasons. One, because the statute requires it, but two, how else are they going to know how to pay it, or that it's actually due? A lot of people don't pay attention to board meeting minutes that might be posted. So, it's a good way to let your owners know when it's due and how they're allowed to pay it.
I normally recommend a board resolution after the fact. Send out the resolution advising that the assessment has been imposed and setting forth the payment terms. But I've got a couple follow-up questions. I'm sure that doesn't surprise you. A couple different things. Assuming we need a membership approval and we're tying this to, let's say, the amount of the special assessment, and the documents say if the assessment's going to exceed, let's say, a certain dollar amount or a certain percentage of the operating budget, you need membership approval. Sometimes boards get confused and think just having that membership vote alone is sufficient. It's really not. It's a bifurcated process. First, you need to get the membership approval, and then you still need the board meeting to impose the special assessment.
Correct. Yeah, I would definitely agree with that.
Okay, and in terms of the estimated cost, be sure you use the word approximate or estimated, right? And not just a finite dollar amount.
Exactly. And sometimes, surprisingly, the special assessment will wind up being less than the amount that you thought you needed it to be. Most of the time it does wind up being more, but you definitely want to give yourself a little bit of leeway there.
And then for purpose, and we're going to talk about loans and purposes later, but for purpose, if you are passing the special assessment to fund a project, that's one purpose. But if you're passing the special assessment to repay a loan that is needed to fund a project, that distinction really should be made on that notice, right, Jane? Joy?
Yeah, no, it definitely should, because the key here is that you're trying to avoid any arguments in the future when you're trying to collect these things. So from the perspective that I'm bringing, I'm trying to make sure that everything is done so you're building a good case down the road if you have to collect that amount. So making it as specific as possible in terms of the purpose. Yes. So if you're passing a special assessment and you don't have a loan that you're repaying, you can simply say the purpose is to fund the concrete restoration project. If you are getting a loan and you're passing the special assessment to repay that loan, it would be wise to say that the purpose is to repay the loan used to fund the concrete restoration project. So that would be the kind of the distinction that you could make.
So Jane made the distinction between regular assessments, as she said, sometimes called dues, sometimes called maintenance, sometimes called regular assessments. Do you find, because you handle collections for thousands of associations throughout Florida, do you find that there are fewer people that don't pay special assessments or more? Is it as opposed to regular maintenance?
I would say that a lot of times it might be better to answer it in the way that if you're delinquent on your regular assessment, you're not going to pay the special assessment either. But some people will pay their regular and not the special assessment, and there are times when owners won't pay the special assessment because they're disputing it. So that might be a little bit different than just not paying the regular. But I would say that in general, if you're paying, it's more a matter of, if you're not paying your regular, you're not going to pay the special. I think more clients or more association members pay their regular and not the special, but I wouldn't say it's by a wide margin. I think that if the key, and I don't know if we want to talk about this now or get into it later, but the key is that, knowing your community, how can people afford to pay this? So I think a lot of times structuring the special assessment payment so that you have owners that are actually able to pay it is key there, rather than, it's not that they're really not wanting to pay it, it's just they may have a difficulty paying it.
What if they challenge?
Could I ask? I have a question.
Absolutely, Jane, pop in.
Joy mentioned several times about sending the notice. What about email, Joy? Folks always ask me about that. Can they send that notice by email?
So I think if the owner has consented to email deliveries for notifications, that yes, you can do that. The statute doesn't say it has to be, it does say mailed, but in other parts of the statute, it does allow for owners to agree to receive those types of mailings versus by email. So I think you would have a good argument as long as you could show that that owner had consented. Yes.
Right. And specifically consented, not
Correct.
Just gave you their email address.
Oh yeah, no, it has to be a specific consent. It's not that, oh, we had the email in our records, so therefore we emailed it. No.
And what about condos that have are required to have a website, 150 units or more?
I don't think that posting it on the website is sufficient because it does say it needs to be posted on the property. But I do think it's a good idea to post it on your website if you have a website, but I don't think that removes your requirement to post it on the property.
Joy, we've seen so many meetings held virtually throughout the pandemic, and we're continuing to see that because the pandemic is ongoing now with this Omicron variant, and so we're not out of the woods yet. Does holding the special board meeting to impose the special assessments virtually give you any heartburn?
Not as long as you give everyone the ability to attend. So, I know some people don't have, some people still have flip phones with no cameras, right? So you need to make sure that if you're providing a Zoom capability, that you also need to have a telephone number that people can call into. I had a big case, or just cases in general where boards had passed a special assessment via phone call. So it was a conference call and there were really no board members in attendance there, and there was someone there running the call, and that was acceptable. There's no reason why you can't do that. So I think if you're having a virtual meeting or a phone meeting, you just need to make sure that you're providing everyone with the ability to access it. And that typically to me would mean both a phone number and a Zoom link.
Okay, so those are the basics. Let's use a real life example of when a board may pass a special assessment. Let's say in a homeowners association, there's a large re-roofing project. The board is responsible for the roofs. They're going to re-roof the individual villas and they're going to re-roof the clubhouse. It's going to cost about $5 million. They do not have sufficient reserves. Jane, how do you discuss fiscal management with your clients in terms of deciding whether or not they want to pass a special assessment or take a loan or line of credit for that work?
There's quite a few things to consider, as I'm sure you know, Donna. One of the advantages of, well, first of all, you have to figure out who has the authority to approve the loan. Just like we said about approving the special assessment, you have to look at the association's documents to see if it calls for a vote of the membership to borrow money. Now, in my experience, most documents do not call for a membership vote. It usually is just a board decision. I like the loan process because then we don't run into the kinds of problems that Joy was talking about, where you don't assess enough the first time because you really don't want to scare everybody. And you end up with multiple assessments, which can make people very unhappy, and unhappy people are less likely to pay. So the loan process gives you the ability to figure out how much you need, and then you can levy your special assessment. Or if you look at your community and they say, you know, we have a lot of folks here that are on fixed incomes, they're not going to be able to pay a special assessment. The loan gives you options of either stretching the payments out over time so that they're paid as part of your budget, or even a combination. Some people might want to pay the loan up front. I often have people want to do that. And then the other folks can continue to have the time payments. And I know vast majority of management companies can manage those kinds of hybrids nowadays. It was a lot harder when I started and we didn't have computers yet. You know, we were still using those old abacus. But the process nowadays is really not hard to do, so that people have an option of which way they want to go. And banks love to lend condos money, and homeowner groups too, because they have very good repayment histories. So, and right this minute, I looked at loan documents this morning for a line of credit for 3.75%. I never thought we'd see interest rates below 4, you know. So it's not a huge burden. You don't pay a large amount of interest. They'll structure the loan so that you only pay interest for the first year or 18 months. And so it gives you a real lot of flexibility. You don't run into that wall where you didn't assess enough. And you can offer people either the special assessment or even multiple special assessments, or payment over time.
But in terms of the option to pay up front, because a lot of people want to do that, they don't want to have to pay the carrying cost over time. You really can't do that until the repayment amount is fixed, which means after the project is finished, and then it amortizes, and then we know what it's going to be. Because if you're using this to fund, let's say, that roof project, we won't really know until it's over what that amount is going to be. So we really couldn't give a payoff amount to owners to say, hey, you can pay this in one installment, correct?
Right. The contractor's going to tell you he doesn't know how much sheet wood you need underneath until he tears the roof off. So you're going to have certain flexibility. Or a concrete project, you know, they never know how much that actually going to cost before they start the project. So yes, you really need to have that kind of flexibility, and you need to keep your owners advised of what's going on, so that when you do have the special meeting to levy the special assessment, the balloon doesn't go up at that point. You do want to keep people informed, but you got to fix the roof. And if you haven't planned ahead, you don't have enough reserves, you got to find the money somewhere. A really big bake sale just doesn't make it. You know, you've got to have your either special assessment or your loan.
Bold statutory disclaimer language that says if you don't fund reserves in whole or in part, you're going to be subject to a special assessment. Although I have to say, I wonder at this point, because it's been so many years that that's been the requirement, if people just have stopped reading that and their eyes glaze over.
Yeah, I don't think they see it. I agree. And, you know, there's certainly been a lot of talk in the news in the last year about building repairs. Yet I still see communities that have difficulty facing reality. And that's a whole psychological seminar we could do one day, perhaps. But yeah, unfortunately, those folks that are on the board have to bite the bullet.
Yeah, and you know what? You do. When you get elected to the board, you have to make the tough decisions. And we saw that during the pandemic. And, you know, there were just so many boards that stepped up, and in the face of incredible, you know, opposition and pressure, they did the right thing to keep the community safe. And that was during the pandemic. And it's really no different when you're talking about being fiscally responsible. I would say for the people listening, if you go the loan route, and let's say you followed Jane's advice, you met with counsel has told you that there are no hurdles to you obtaining a loan or a line of credit, that the board has the authority to do so. Just know, don't sign that letter of commitment before you have counsel review it, because often once the letter of commitment has been signed, if there's certain conditions in there that are not supported by your governing documents, that's going to be problematic. And certainly most lenders, if not all lenders, want an opinion of counsel that verifies and confirms that the board has the authority to pass the special assessment.
Yep.
Okay.
Yep.
So
Certainly.
Joy, back to you. It's your department is the one that ultimately is going to be contacted when people don't pay the special assessment. And so what are the consequences if the board got this all wrong? The notice wasn't 14 days. They didn't outline all the purposes for the special assessment. They may not have listed costs, or let's say that there was a material alteration component to the project for which the special assessment is being funded, and they didn't get membership approval. All of these things, pick and choose one or all of them, have happened. What happens now?
So if it's a issue with the notice, whether it wasn't sent out in the proper amount of time, or it doesn't have exactly the information needed, sometimes that's a judgment call in terms of whether or not they want to redo it. I typically always tell them, first of all, if it's a date timing issue, like they didn't send it out in 14 days, within 14 days, or, you know, in that amount of time, they didn't give them that notice. I always tell them, you have to basically redo this. You have to ratify your prior decision by giving a new notice and, you know, correcting that issue. With respect to how specific you have to be with the estimated cost and purpose for the special assessment, that's a little bit of a judgment call, but I always think it's better to err on the side of caution, because what you don't want to do is get a year down the road and, you know, a few thousand or more dollars in attorney's fees and have a judge tell you, yeah, no, it wasn't specific enough. So I would always say you want to ratify by readopting the special assessment at a new 14-day, you know, notice, do a new 14-day notice, have a new meeting. The question about the material alteration, though, is different because that requires you to certainly fix that before you proceed. You cannot retroactively ratify a special assessment that was passed by the board that was used to fund a material alteration that required an owner vote. There's a case that came out last year on this point, really shocked a lot of people in the community association community, but it makes sense from the perspective of, even if, so in that case, and what I've seen clients try to do is that they have passed a special assessment for a project. Part of the project was a material alteration. They will then get a unit owner vote in the middle of the project, and the owners will say, yes, yes, we agree. Well, the court said that wasn't sufficient. You have to get the vote before you've actually, you know, passed the special assessment, let's say. So that's what I would tell clients. And that's something that you really need to be looking out for, whether this is a material alteration that requires a vote or whether it is a, you know, something that the board is allowed to do. And it can get very tricky. And I'll kind of bring it up in the context of our roofing project that we're talking about. So it's the associations and the board's responsibility to handle the roof replacement, But if the board is then saying, oh, but we want to change the look of the roofs, we're going to go from shingles to terracotta, or we're going to go from terracotta to, I don't know, tin roofs, whatever it may be. If you're changing the look of your roof, even if it's your responsibility to maintain those roofs and you're the one responsible for the repair and the replacement, you have to get an owner vote to actually do that material alteration. It's the same as when you're painting your community, right? Same thing, you're required to maintain the paint and keep up the community. But if you're going to change the color, you got to get owner input and you got to make sure that that's done. So it's very tricky when you're looking at these things. In terms of what's material alteration and what's, allowed without a unit owner vote.
What happens if you've passed the special assessment for the roof project, and in addition to replacing the roof, which is repair, they're changing to barrel tile from a flat shingle. They didn't get the membership vote midway, and let's say they've pushed out the payments, the first of each month for the next 5 months. Okay, in month 3, somebody complains to the division. What do they do with this? And they're going to have to do this over. They're going to have to get the membership approval and everything else. But what do you do with the people who've already paid months 1 through 3 on those installments? What happens then?
That's a really good question. That's like a law school exam question.
Sorry, I threw you a curveball.
I don't know that I have the exact answer, but I think, these are when practical considerations come into play. So most of the time, those owners that have already paid that special assessment, they're not interested in getting it back. They're not interested, remember, associations are made up of their membership, and all of those members are responsible for paying and for maintaining that community ultimately. So a lot of owners, even if the association does something wrong in this respect, are not interested in bankrupting the community by having all of this undone. So those members that you have that have already paid, my answer would be they would have a credit towards the next special assessment that you had to pass in order to correctly do this, right? So, if they asked you to refund the money, I suppose you would have to, honestly, but most of them probably aren't going to do that because they're just going to have to wind up paying when you do it properly the next time.
Not to mention, your board has already signed large repair contracts with vendors, and we're going to talk about that later, but that does leave you vulnerable to collection efforts if you have to stop paying your vendors, or, interest and late fees if you're late paying your vendors. So I would imagine that's a consideration as well.
Agreed. And, that's always the tricky part, is what happens. And a lot of associations get nervous when, they've realized they've done something incorrectly midway through the process. They don't want to give any owner ammunition to come back. But two wrongs don't make a right. In other words, and then there's always that, saying about the cover up is really what gets you, not the crime or not the, the error. So you really want to fix it, and you have to do a good job of explaining to your owners what happened. 9 times out of 10, probably even more, this is nothing that's intentional. It was just a mistake, So fixing it and being honest with your owners about what happened is usually the best course of action.
So Jane, I'm sorry, go ahead, Jane.
Back up for 1 second. I just wanted to clarify that the material alteration voting that y'all talk about does not necessarily apply in an HOA context. So that is condominium law, and it is not in the law for homeowner communities. There might be something in your documents, but it's a totally different set of legal requirements between the condo and the HOA.
Absolutely.
So I was just coming back to you, Jane, with the material alteration before we get off of it. Let's assume in your HOA there is a requirement for membership approval for material alterations. We go back to our roofing project, and the board says, wait a second, we have supply chain issues. We can't get the same roof materials. Is that an exemption to the material alteration approval requirement?
In some cases, yes. There is an exception to the material alteration requirement, even in the condo setting, if you have competent professional evidence that the work needs to be done in order to protect the common elements. The primary case on that was a seawall situation where the engineers said, you must put in a seawall to protect the structure of the building. Some owners objected and the court said, no, you can't ignore the fact that you need to take action to protect the common elements, even if you didn't have a vote of the members to approve it. So in your example, Donna, we'd have to look at the facts. Is the supply chain issue going to go on for so long that the failure to fix the roof would create greater damage? Or is it something that's going to be 3 months and we can just wait a few months? But in many cases, those kinds of facts will lead to a conclusion that the board needs to go ahead and get the work done now, because there's too much damage is going to result otherwise. I had a case not too long ago with some clients that are located right on the ocean, and the adjacent road is A1A. And there's a large culvert that goes into the ditch next to A1A. And without any real explanation, it was probably some kind of sinkhole situation, the culvert fell in. So only those with helicopters could come and go, right? And they needed to put in that culvert immediately. It wasn't budgeted for, it wasn't anticipated. It was definitely a material alteration, but it was a real, because they were going to a whole different kind of material, but it was a real necessity, and there just wasn't time to have a vote of the members. And they did the right thing. They went ahead and got it fixed.
Was there time in that instance, Jane, to have the 14-day board meeting?
No.
So I had that in a situation with one of my clients as well. And they needed to pass that special assessment immediately for emergency electrical work. Then they ratified it later with the 14-day notice.
Yep. Well, in that case, that client actually had an open line of credit that they kept all the time, just because they're on the ocean and we all know what storms can do. So they had planned ahead with it. So they were able to access the funds to get the work done immediately. So a bank will typically charge you a small fee. I've seen maybe $200 a year to maintain an open line of credit. That can be a really good thing to do, especially if your building is not brand new, and most of us aren't anymore.
And listen, folks, if you have reserve funds, you can get a membership vote to use those reserve funds for an emergency. Or if you have a line of credit, an open line of credit, that's what it's for. I mean, I think all of us on this webinar would advocate for fully funding your reserves and having a line of credit. Those are really useful resources if and when you have an emergency situation.
Right.
Okay. So Joy, you know what's going to happen? Most of these large special assessments tied to large repair or renovation projects are going to happen over a course of some time. Okay, they're not going to be wrapped up in 4 weeks. Sometimes we're looking at multi-year projects, or at the very least multi-year installments for the special assessment. And during this time, you know what's going to happen? People are going to sell their units and new people are going to move in. So the question always comes up, does the board pass a resolution in terms of the payment terms and insist on a due-on clause sale, meaning when a unit sells, the purchaser has to pay the entire balance of the special assessment owed? If you can, walk us through that. Are there pros and cons to that?
Yes, there are definitely pros and cons. And frankly, I think there's more cons than there are pros, at least if you aren't careful as to how you phrase it. So a lot of times associations will provide their owners with 2 options to pay a special assessment. The first would be lump sum. And sometimes that's tied to a repayment of a loan. So you get a little bit of a break on the repayment because you don't have to pay interest. The next, option would be payment in installments over, however many months, whatever. And there's usually even a provision that if you don't pick one, that you will be presumed to have chosen the installment one. In other words, if they don't receive your lump sum payment by X date, then you will be presumed or assumed to have chosen the default or the ongoing installment payment plan. The issue with it's not hard to show liability from one owner to another if someone else takes title if you have installment payments due in a special assessment. It's almost the same as having another regular assessment in terms of it just being due on an ongoing basis. You have to make sure that you know, most of the time when someone is taking title in a property through a voluntary sale, they request an Estoppel certificate and a payoff, and you want to make sure you reveal the existence of that ongoing assessment in that payoff and in that Estoppel certificate. But the due on sale clause is very bad in terms of if a bank forecloses and takes title to that property. So banks have argued when a bank takes title to a property in association through their own foreclosure sale, they're typically limited to the lesser of they are by statute limited to the lesser of 12 months past due assessments or 1% of the original mortgage. So that already means that you're losing all of that, special assessment that came due prior to them taking title. However, they are responsible for the ongoing installments of the special assessment unless you have that due on sale clause. Banks have successfully argued that if you have that clause in your special assessment resolution or adoption, that it became due when title transferred, and therefore it's part of the transfer amounts. And courts have held that they're entitled to that protection. So if you want to put a due on sale clause in your special assessment, resolution, what I suggest is that you put due on voluntary sale, because a bank foreclosure sale or a tax deed sale, let's say, a tax deed sale wouldn't help you regardless, but it would. In terms of what we're talking about, if it's a judicial sale of any kind, meaning a foreclosure sale or a deed in lieu of foreclosure or a anything that is not a normal sale, okay, a normal voluntary.
That's involuntary,
Exactly.
correct?
It's considered involuntary. So if it says voluntary, a due on voluntary sale clause, then you would have a good shot at arguing that the bank can't take advantage of that by saying none of it's owed. So that's the big con that I would say. And unless you kind of, negotiate that carefully in terms of having that voluntary word in there, you're going to wind up not being able to recover any of that special assessment. And you may have 5 years left on it, or, who knows?
I hope everybody, what you just gave away, and you gave that away, Joy,
I did.
was very useful advice. Okay, because the advantage to a due on sale clause when we're talking about a voluntary sale, Mrs. Smith is just selling her unit, is you get that influx of cash. Okay, you don't have to wait multiple months or years to get it, and you avoid the pitfall of, if you just say due on sale, as Joy said, you can wipe out a lender's responsibility for all the future installments. I imagine during the recession, due on sale clauses for special assessments made absolutely no sense, given how many units were in foreclosure.
Right. And I don't know that a lot of associations have that. I have a lot of associations who want to require it be due on sale when there's a transfer of title. And, I have to go, well, did you put that in your special assessment? No. Okay, well, then you're not allowed to do that. You can't force the issue if it's not in there. But if you do put it in there, you need to be very careful about how you're wording it.
So Jane, back to you. If we just budget, let's say we're going to pass a special assessment now, and we're also doing the 2022 operating budget. If we just budget for to repay a special assessment, is it still a special assessment?
If it's a line item in your budget, it's a part of your budget and a part of your regular assessment. But you have to be concerned about what the bank is requiring. And so that's something you need to discuss with your counsel when you're ready to sign the documents. Some banks will require a specific special assessment outside the budget. Some banks are perfectly fine with a line item in the budget. But from a legal perspective, you can go either way. It depends upon your loan documents with your lender as to what you're going to be required to do.
So check those docs. Joy, I've had this come up recently, and again, we get back to the issue of units being sold while there is a pending or even a ratified special assessment. We've got a lot of managers listening today, and unless the unit's in foreclosure with us, they are the ones that are going to be filling out typically the Estoppel certificates when they get those requests. How should they handle the issue of the special assessment on that Estoppel certificate?
So if it's already adopted, and then I think that you absolutely, of course, have to reveal its existence, and you want to, reveal it in the same way that you would a regular assessment, meaning you want to, if it's due in installments, then you want to indicate, when they come due, and how much is due per installment and how long it goes. And then if it hasn't been, the tricky part, I think, becomes when it's a special assessment that hasn't been adopted, but it's under consideration. So what does that mean? Well, has the board been having meetings regularly talking about this project and about how they're going to pass a special assessment? Have they actually noticed the board meeting at which the special assessment is going to be considered and adopted? So those are situations where you have to be careful, and it really is a fact specific analysis where you need to look at it on the basis of the specific facts of the situation. So if a manager has a situation like that, they can reach out to counsel and ask, but you don't want to find yourself in a situation where a new owner says, wait a minute, my Estoppel certificate didn't say anything about that, therefore I'm not responsible to pay it. And they have a good argument that you've waived the right to collect, especially certainly if it's already adopted. Even if it's not due yet, okay? If it's been adopted, you have to reveal the existence. If it hasn't been adopted, but you've had a lot of conversation about it, or the board meeting has been noticed at which it will be adopted, it's already been noticed, then you really need to consider revealing the existence of that special assessment.
And I don't think the statutory template form is all that helpful. I know a few years ago, they revised the template to add in additional questions related to that particular unit, any violations, what have you. But I don't find the statutory template form to be all that clear when we're talking about certified or ratified assessments that are not yet due and owing. So I think your point is really helpful.
Yeah. And I think as you've been pointing out, not only do we get those statutory forms, we often get requests from lenders that are going to finance the purchase of the mortgage. And if there may not be a legal obligation to answer those questions, but the association is aware that somebody's not going to be able to buy if the questions aren't answered. And you have to be very cautious about that, especially if you're in the process of a special assessment. And that's when you call joy in advance before you answer those questions.
And you can charge to answer those questions, correct?
Yep. Yes. Yep.
So don't be doing it for free, folks. You can charge for that.
Yep. You can tell the lender that, there'll be a reasonable fee to go with that so that you can consult your attorney without fear.
Well, listen, often they're very lengthy too. I've seen 5-page lender questionnaires where they're asking everything regarding to, is there radon exposure, the environmental integrity of the property, how many percentage units are leased, which in many communities, they don't really know at any given moment what percentage is leased because some people are not being entirely honest about leasing their units. So there are pitfalls. I would recommend don't fill those out just out of hand, contact counsel, figure out whether it makes sense, particularly the wording, because I've seen some egregious wording on those lender questionnaires where it's like under penalty of perjury, I'm providing this information. I would suggest revising that. So Jane,
well, that's where you get out your red pen, right?
Exactly. So we've got about 10 minutes left. We're like flying through this. We may go 5 minutes or so over to get through everything. But here's another big issue, Jane, that always comes up. And you touched on it early on. You don't want to have to keep going back to the well with your owners. Even just from a psychological standpoint, it's a lot to be hit with multiple special assessments in a very short period of time.
Right.
And sometimes boards underestimate, either because they're just being overly optimistic or because their contractors have not been entirely honest with them about the scope of the job. So how can boards mitigate the risks associated with not having to pass multiple special assessments and getting it right the first time?
Well, any special assessment should have a fudge factor in it, a contingency factor. I usually see around 10%, but maybe for larger projects like a concrete restoration, you would want to have 20%. Sometimes you'll have an expert that's guiding you that can give you a reasonable idea of what the contingency should be. But you should have a contingency factor unless you've got reserve money that will cover any shortfall that there might be. And of course, as we also talked about, one option is to borrow the money to start with and then levy the special assessment once the work is completed and you know exactly what you're talking about. But you have very unhappy people. I'm sure Joy gets to chat with them all the time if you're talking about multiple assessments in a short time period. So you really should do anything you can to avoid having that happen.
So if they just put down on the notice in the agenda, $5 million proposed assessment for roof replacement project, that's all they put. Does that include the legal fees, the permitting fees, all the soft costs associated with it? Joy, I'm assuming you're going to say, I prefer to see that all laid out and broken down, but what do you think? And this is a question for either of you.
I don't think it's possible for you to lay it all out. And I think you're actually maybe creating more of an issue if you try to lay it out. You know, you maybe could say that, in other words, you don't want to necessarily delineate amounts to each of those items. You know, if you want to get more specific and say, you know, it's funding this project, which includes blah, 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 you know, or, you know, legal fees and permitting and, you know, but I wouldn't assign a number to those things. And I don't even know that you need to get any more specific than to say the project that you're funding, you know?
And that's it, just it, project and not plus associated cost or hard cost or anything like that.
That's what I usually try to do, is to say, including reasonably related costs or something like that.
Okay.
Just sort of catch all, but not the specifics, because you never know.
Mm-hmm.
So Jane, they have to pass a special assessment. There's no doubt about it. They got to do a second special assessment. Do they do that special assessment to subsume the first assessment or run concurrent special assessments? What's your recommendation?
Typically, I find it to be a little bit cleaner and easier for the owners to understand if you have two separate special assessments. Joy might have a perspective from the collection side of it, if it makes any difference. I don't think the law says one way or the other. I don't think the accounting rules say one way or the other. So I think you have to think about what will people best understand. And if you didn't collect enough the first time around, the best thing to do is just say, mea culpa, we're very sorry. Here's where we were short. You know, just be as open and transparent as you can, because that's the folks you need to worry about, the ones you're talking to, your owners. They've got to feel that you didn't screw up, that that's not why there's a shortfall, that it was just stuff happens. You know, we didn't know about the extra plywood, something like that. What's your thought, Joy?
So it's kind of so just let's just do something practical and talk about, like, we passed an assessment that's due from an owner in $500 installments, you know, over the course of 2 years. Okay. For 2 years, they have to pay $500 a month. If you then need to, you know, have more money because additional costs have come up, if you try to subsume the first one into the second one, from my perspective, how am I going to list that? And they don't pay. This is all assuming they don't pay. How am I going to list that on a collections letter? Like, because normally a special assessment, when you pass it, it's, you know, it's equal installments, right? And so it gets very complicated from laying it out for the court, let's say, or even making it clear to the owner what they owe. So I agree with you that I think it's usually always better to have a second special assessment. And I've had cases where I've had special assessment 1, 2, 3, multiple special assessments. Sometimes they're to fund the same project. Sometimes they're to fund a separate project that they decided to start doing at the same time. And I do think it makes it clearer, because then at least you have definitive beginning and end dates for each special assessment that has been adopted.
And that reminds me of one other point that I don't think we've mentioned. In a condominium, it is not unusual that everybody does not pay the same for their regular assessment. It's based upon the square footage or some relationship to the size of your unit, so that the 3-bedroom unit is paying more than the 1-bedroom unit. And those percentages apply to a special assessment also.
Well, sometimes, Jane, because I've had documents where the regular assessments are based on unit type or square footage, but the special assessments under the documents are on a prorated basis.
Really? Never seen that.
Strangely enough.
So just goes back to your initial point, Donna.
But you're in a different market. You know where I am.
Yeah.
I'm in South Florida. So it's very different, but check your documents, because your point's well taken, Jane, that don't just assume that you're going to levy the special assessment in the same percentage that you levy the regular assessments. It might be the same, but it might not be.
Sure. But don't assume the other way either.
Exactly.
Don't assume that it's equal either.
Exactly. So Jane, these are difficult waters to navigate. I mean, there are people that have been living in some of these buildings. Let's take a condo, for example. And, you know, they moved in their 40s, they're in their 80s or 90s now. At this point, they're on fixed incomes. And now they're being hit with very large special assessments, because over the years, the owners have waived reserves. They've had different boards who've had taken different approaches to maintenance. What do you say to those people? And I've been to those meetings, and your heart goes out to them and says, I can't afford these special assessments.
Well, they should have been funding reserves, but I'm sure they don't want to hear that or be reminded of that. They have been reminded every time they voted to waive reserves that somebody was going to have to pay the bill at some point down the road. Yes, I know that some are, the Green Banana Club. I don't buy green bananas because I might not live to eat them, right? And folks have that kind of attitude in condos sometimes. They might be able to get an equity line of credit against their home. People that have lived there for 40 years often have paid off their mortgage. If they're over a certain age, they can consider a reverse mortgage, although I don't like those for other reasons, not just because Joe Namath sells them, right? But
a couple others, I think Tom Selleck too. I see the Tom
is that
Selleck
who it
one.
is? Okay.
Yeah.
But it might be time for them to think that they need to sell their condo, especially in today's market where there are a lot of buyers. Maybe that is the option, because if you can't afford to live there, then you can't live there. And there's just no matter how sympathetic you are, there's no easy way around that.
Yeah, I think that's good practical advice. Listen, I also think we're going to see a lot more condo terminations of older buildings in desirable locations, where the majority of the owners, or the vast majority of the owners in the building, find themselves in that situation where they may be able to get a valuable return on their investment because they bought the unit decades ago, and they just don't have the finances to support the ongoing maintenance needed.
And it's going to go up.
I did want to make one mention, and I had a person who watches our webinars regularly make this recommendation, and I thought it was a good one for investor owners. And we have a lot of them. I don't know about in your market, Jane, which is Treasure Coast, but certainly in Southeast and Southwest Florida, we have quite a few investor owners. They need to talk to their accountants about the fact that when they pay special assessments, particularly large ones, they increase their tax basis. So for some of our listeners, I don't know, this may be a light bulb moment for them, but special assessments are not always a bad thing for investor owners, because it does allow them to increase their tax basis and offset when they go to sell those units. So Joy, same question. We've got people who are unfortunately maybe in the position where they cannot pay these large special assessments related to a significant repair project. The topic of payment plans always comes up. How would you structure that? And should a payment plan be offered right off the bat? I'm going to say no, because you want to get the money in as soon as possible, particularly if you're signing repair contracts. But how would you structure a payment plan, and when would you offer it? Before someone's in collection or after?
Well, the problem with offering it before someone is in collections is, well, then why didn't you offer it to the rest of the membership, right? So you kind of have to treat all of your members the same. And that doesn't necessarily mean that you aren't allowed to do different things sometimes. It just means it has to be, you have to treat every person in a particular situation the same. So what I mean by that is that, honestly, I don't necessarily recommend payment plans prior to someone becoming delinquent, unless it's a very minor payment plan, or there's a overarching reason why. For example, during the pandemic, we told a lot of our clients, one, don't offer this, or don't just excuse, payment of maintenance. But if someone comes to you and says, I lost my job, but, this is what's happening and I can make, these payments, sometimes there are considerations, right? But in this type of situation where someone's just not able to pay in general, you really need to get to the point where you have an enforcement mechanism that will allow you to eventually collect it, which would be collections, foreclosure, that whole process. And if they want to enter into a payment plan, once you have that process started, then you'll know that you have an enforcement mechanism if they default, right? And honestly, the payment plans themselves, while it's somewhat, dependent on what the association wants to accept, I don't really recommend longer than a 2-year payment period for anything. Some of our clients are fine with having 5-6-year repayment plans. I'm not going to tell them not to do that, but I also don't recommend it, just because a number of things could go wrong and you're not really getting your money back, if that makes sense. It's a very difficult situation. I don't have a fantastic answer other than I would just make sure you have to protect the rest of your community. So you have to weigh what's happening with this one person or a few people against the rest of your community. And so you have to maintain the financial health of your organization and your community. And so you have to make sure that you're not putting everybody else in jeopardy because you feel sorry, rightfully so, for someone who's not able to make those payments.
And if there's a payment plan in place and the unit is sold, that those amounts, do we know, we can go on the Estoppel certificate and they're collected?
Absolutely. So someone, and I want to bring this up, with the Estoppel certificate, everyone needs to understand that when you provide an Estoppel or a payoff for a property that's being sold, and the reason why it's so important that you reveal an ongoing special assessment, but also a regular assessment or any past due, is that puts the new or the buyer on notice that they are now responsible for that amount. So I think there's a little bit of confusion about that. That's why it's so important, because if you fail to put those things on the Estoppel, then the reverse is true. They can claim that they weren't on notice and therefore they don't have to pay. But if you put those amounts on the payoff and on the Estoppel certificate, they become responsible because you've revealed it to them, in addition to the fact that the statute says they're responsible for it.
And folks, we're just at 1:02, but we're gonna go over for 5 more minutes because we got some more information we want to talk to you about. Jane, I don't know if you've ever had this situation lately. I have, where there's been some large special assessments. A board got in and they're saying, we're going to do this because it needs to be done. And I'm not talking about discretionary improvement projects. I'm talking about overdue repair projects. and you've got a percentage of the members that think they're going to recall the board to stop the special assessment, okay? Doesn't really work that way, does it?
Well, especially not if you've got contracts signed for the work to be done. The contractor is not going to let you out of the contract just because you've decided it wasn't the right thing to do. So no, and if the work needs to be done, the work needs to be done. I mean, I don't know how else to say that.
This is like back in school when somebody ran for, school president and said, I'm going to get better food in the lunchroom and free ice creams on Friday. Don't believe it, dig into it. We're in election season right now. And if you have board candidates campaigning on a platform that they are going to stop a large pending special assessment, you're going to need to understand if contracts have already been signed, as Jane just said, all you're going to do with stopping a special assessment now is subjecting your association to breach of contract claims.
Right.
It's going to be even more expensive.
Yep.
So ladies, we've moved on to common surplus. Okay. Our roof project has been done. We've passed our special assessment. We've collected what was owed. And guess what? Surprisingly, we've come in under budget and there's money left over. All right. This is rare, but it happens. And this is treated as common surplus. So first to Jane, what do we do with it? How do boards treat what's called common surplus?
Well, you cannot buy a gift for your beloved attorney. That's not on the list, as much as you might want to do that. But it's money that belongs to all the owners, and it can be either used, it can be refunded to the owners if the project is completed. That it's only surplus after everything is done. But if you've completed everything that was noticed in your notice that Joy talked about, then it can actually be refunded to the owners in the same way that they paid it in. So if they paid it in equally, they get equal shares. If they paid it in percentage wise, they get percentage shares. Or it can be used to apply to reduce future expenses. And that's typically what I see boards do. It's just not useful to write everybody a check and then start sending them a bill for the next year. But you can hypothetically refund the money.
Can you stick it in reserves, Jane?
It's going to depend upon your budget. Numbers don't just get stuck in reserves. They are based upon a specific formula. So if your budget for the next year shows that you need to fund reserves at a certain level, then yes, it can be applied to that. But you can't just say we're gonna, add more money to reserves, kind of, the same way sometimes they decide how much will go into the reserves by pulling a number out of a hat. There is a formula that's supposed to be used.
Let's say the board was gonna write a check and a unit just sold 2 weeks ago. Does the prior owner get the check or the current owner?
Nope. When you sell your unit, you sell your share of the common surplus also. So the whole enchilada goes along.
Yeah, we get that sometimes. You heard it here, folks. It may seem unfair that you paid in, but your purchaser, whoever owns the unit at the time, is the one who gets the common surplus.
Yep.
So Joy, any last comments or thoughts for our listeners? And we have managed to stay steady at almost 500 people throughout this entire webinar. So good job.
Yeah,
the only comments I would make, I'm sorry, Jane, go ahead.
No, go ahead.
No, I was gonna say the only comments I would make is, this is a very important topic that we've covered today. And I think it's important that you should take your time as a board when you're considering a special assessment to just take a few minutes and talk to your attorney about it, because we can save you a lot of time and trouble. You may pay a little bit of money for advice in the beginning, but it's going to save you a lot of heartache in the end. And I see it all the time. Associations do not want to hear you need to redo this. It's not a fun thing to do, especially when you have a contentious special assessment. So that's what I would just say.
Jane, any last thoughts to leave our almost 500 people with?
Nope, I'm good. Thanks, ladies, for chatting today. I think Tammy has a message.
Thank you all for joining us. Tammy?
No, there's no closing statements because this isn't a credited class. So it's just informational, but just a reminder that in 1 to 2 days, the participants and the registries will be receiving an email that will have a link to the recorded version of this webinar.
Right. That's what I was thinking of. The recording will be out there so that if you have other members of the board that didn't get to watch and can't sleep, you can share it with them.
Hey, this will keep them up. Listen, Joy, Jane, thank you so much for joining today and discussing special assessments. And I think this topic has taken on even greater significance and certainly will in the aftermath of the 2022 legislative session, where we are expecting some significant changes when it comes to reserve funding and maintenance obligations. So thanks, everybody.
Thank you. Everyone have a great day.
Bye, guys.